Okay, so Justice Wilson, for social policy reasons, says that the Labor Relations Board can have the jurisdiction to reinstate yeomen. And it's because it's a comprehensive scheme to protect non-unionized workers. And dissent, Laforet agrees with her, but does so at step one. And his justification is that there is no intrusion because the times were very different in 1867. The role of the government was minimal, and with regards to employer-employee relationships, all they did was make sure that contracts were enforced. But there wasn't any collective bargaining or extensive labor standards. So these sort of broadly stated labor standards are a new obligation that transcends the obligation between two parties. And the underlying social and economic philosophy of protecting non-unionized workers, or facilitating employer-employee relationships, is in sharp contrast to what the courts did at Confederation, which was simply enforce contracts. So before we move on, I just want to clarify the checkerboard problem. Was that Sobeys addressed through the application of looking at what the Superior Court role was in the 4 colonies plus England. So when you look at the Superior Court and their role in adoption, for example, was it adoption? Anyway, when we challenge or when we try to transfer a jurisdiction, we used to look at just what the Superior Court in that province did, but Superior Courts in different colonies at the time of Confederation had different roles and different functions and different powers. And so if we looked at just an individual province, there might be non-uniformity in the powers that could be transferred to a specialized tribunal in different provinces, leading to a lack of uniformity. And so that was the checkerboard problem that was addressed by having the majority of the 4 original colonies plus England. Great. So on to reference regarding the Young Offenders Act. There was a young person in Prince Edward Island who challenged the authority of the provincially appointed judge in the youth court. So in the appeal to the trial where he challenged the authority, they determined that the authority of the youth court was valid because the penalties were limited to 3 years. And these broadly conform to the penalties available in superior courts in relation to the same offenses committed by adults. So the Act creates a new and distinct legal regime, specialized for young offenders and for a social purpose, which we'll get to. So that was then appealed to the Supreme Court, and Justice Lemaire says it's a comprehensive scheme designed for a specific age group. This is novel jurisdiction. Also, less stigmatized offenses with lighter sentence were historically within the jurisdiction of the inferior courts, thus saying that the youth court, though dealing with criminal matters, is absolutely valid. Wilson and McLaughlin do the test from Residential Tenancies Act, and they decide that it does infringe on the historical power of Section 96 courts. It is a parallel judicial regime, and then again jump to the social policy decision and decide that it's novel jurisdiction and necessarily incidental to the broader social policy aims of the Act, which creates the youth court. And those are rehabilitation rather than punishment and stigmatization. Laforet and Roux-Dubé, they also decide that the youth court has jurisdiction, or jurisdiction can be transferred to them because it's novel jurisdiction, so it passes at step one. They go further and comment on the Residential Tenancies Act test, though, and cite that when an inferior court is being transferred jurisdiction or holding unique, when it's being determined that they're holding unique jurisdiction, steps 2 and 3 are a little ridiculous, because if it is intruding on the functions and powers of a Section 96 court, then it must be judicial in some capacity, and it must, presumably that is a central role of the specialized tribunal. And so there's a foreordained conclusion, and there's no need to go through it. And in the 2 cases we've seen, it's interesting that the Wilson, in both Yeomans with regards to the Labour Relations Board and here with the Youth Justice Act, they go through the process and determine the exact same thing as Laforêt, but they determine it on step 3, actually after step 3, that it's okay because of the social policy and the broader aims of the legislation, whereas Laforêt seems to be taking a more nuanced approach to interpreting what the legislation actually is, rather than just looking at the nature of the dispute and the remedy. So, anyway, Laforêt decides that it's a novel jurisdiction, and so we have 5 people at step 1 deciding that it's valid, and 2 at step 3 who went through the whole test. So the topics we covered today were Tom Coe, which is the precursor to the Residential Tenancies Act, and that established that it was important to look at the administration or look at the institutional and administrative context that the judiciary or the judicial functions are in, and not just whether or not there are judicial functions. And that relates to step 3 of the Residential Tenancies Act. And the adoption, reference to adoption and Toronto versus York in 1938 reflect 2 different interpretations of Section 96 and how to protect those roles. The test in adoption, if I remember correctly, was simply to see if the power that the impugned law or impugned legislation, see if that power was conferred in an inferior court. And in that case, they found it was the English Poor Court, which was an inferior court at the time. And then in John East, they take that a step further, and they first decide whether or not it was judicial, and then they decide whether or not the impugned legislation was part of the superior court. So here they switch focus and they start focusing on the superior court. Then we get to the Residential Tenancies Act, where they develop the 3-step process, and in that then we moved on to Yeomans versus Sobeys, where they cited Grondin in order to help answer the 3 questions that they needed to answer before they moved on to the 3-step process. And Grondin was the evidence that, or it dealt with the fact that some of the jurisdictions were shared between the superior and inferior court. And how do you decide what level of sharing is acceptable in order to transfer the power to the inferior court? And it was decided it should be broadly coextensive. And in the Grondin case, it appeared to be broadly coextensive to me, but it was still decided that it wasn't coextensive enough to grant the jurisdiction to the provincial court. And then in Yeomans, they continue to develop the Residential Tenancies Act 3-step process and apply it. Same with the Youth Criminal Justice Act, the reference there, and we see the dissent from Laforêt questioning this process. So, from 1938 until 1989 and on further, we see the development of the decision-making process regarding the transfer of jurisdiction from Section 96 courts to inferior courts, and and also deciding where unique or novel jurisdiction should lie. Great, and that's Constitution Week 5.